My name is Maria Clarissa Talia and I'm here to represent Smart Wikan Professionals Webinar Committee for today. Smart Wikan Professional is an institution that engages in education and law trainings, law, taxation, accounting, intellectual property, customs, and business. Established in 28th of March 2015, based on Company Deed of Incorporation number 6, year 2015, Smart Wikan Professional has become one of the leading training providers in Indonesia, aiding citizens of Indonesia in mastering skills required to develop Indonesia into an even better and ideal country. We have collaborated with a vast range of institutions. Amongst our records are Badan Arbitration Nasional Indonesia Perwakilan Surabaya, or for short BANI Surabaya, and Asosiasi Konsultan Hak Kekayaan Intelektual Indonesia, also known as HKIAC Indonesia. Today we are presenting Solving International Business Dispute, the Arbitration Method, presented by Dr. Ricardo Simanjuntak from Ricardo Simanjuntak and Partners Law Firm, and Mr. Byron Perez from HKIAC. Next, allow me to introduce the moderator for today's webinar, Ms. Ketut Oktania Vineta Diarsa, SS, SPD, SH, MPSI. She is the President Director of Smart Wikan Professional, partner of PDB Law Firm, advocate, tax attorney, mediator, and intellectual property consultant. Now, without further ado, we will turn the time over to Ms. Ketut. If you may.
Okay, thank you, host. Okay, good morning to our interviewees today, Mr. Ricardo Simanjuntak and Mr. Byron Perez. And good morning to our participants today. As previously introduced by the host, I'm Ketut Oktania Vineta Diarsa, and I'm the moderator for today's webinar with the topic Solving International Business Dispute, the Arbitration Method. As we know, during this pandemic, many disputes occurs. Now, I will read for the curriculum vitae for Mr. Ricardo Simanjuntak. Dr. Ricardo Simanjuntak, SH, LL.M, ANZIF, CIP, is the founder of Ricardo Simanjuntak and Partners Law Firm. He received bachelor degree in law in Universitas Sumatera Utara, and he received master degree in international commercial law in the University of Nottingham, England. Dr. Ricardo has been frequently invited as an interviewee, one of which during APEC 2014 in Beijing. And this morning, Mr. Ricardo will present about solving international business disputes, the arbitration method. Okay, Mr. Ricardo, you may start your presentation. Mr. Ricardo, would you like to share screen by yourself or we as the host?
Please help me to
screen share
for the presentation, please.
Okay. Here it is.
Yeah, good morning, all of us. Assalamualaikum, and wish you all in good health, especially in these very, very tough days, tough weeks. Yeah, hopefully after 20th we can hear better news. Yeah, even though maybe the government will continue, but I hope that the situation is not like as bad as now. Yeah, it's getting better. And hi, Byron, thank you very much for giving me opportunity to participate in this discussion, and also to my friend Doni, Smart Wikan Professional, that we always come to the opportunity to provide more information to societies. Okay, I think we have a very, very interesting topic here, solving international business disputes. and arbitration method. Yeah, let me first check my. Okay. If we see that, I think even though arbitration has been popularly known as one of the alternative dispute settlements, but this morning we are talking not only arbitration, and I think by the presentation of Byron, I think Byron also wants to introduce the role of Hong Kong Arbitration International Center as one of the, I mean, a strong international arbitration institution in ASEAN. Yeah, if we see that Indonesia, I think we are happy to see that Hong Kong investments in Indonesia is getting bigger and bigger. So if we see our latest information that we have Hong Kong as part of their neighboring investments, they sit at third biggest now for the investment in Indonesia. Yeah, so it goes to the transportation, warehouse, and recently we also have a very interesting international seminars hosted by Hong Kong business community. I'm not mistaken. They're focusing on getting more information about business opportunity in infrastructure, which is very linked with the government's plan and visions for giving more or strengthened point to establishing our infrastructures in order to boost the economy in all of area Indonesians. I think I must start with my presentations. If we see that business that's about the parties legal relationship, and parties or business players focus for what we call that, for getting what they are planning as what I mean the objection of course will be profit. Yeah, and in the process they are linked with the commitments. Yeah, commitments. So I mean business players through international relationship are linked with commitments, what we call as contracts. So the question is why? I mean, why do the disputes occurs or take place? I think I must start with my first presentation. Yeah, I think if we see that there are so many reasons for the dispute take place in the business communities. First, yeah, we see that so many business as well. I've been practicing for 20 years as a litigators. I see many deals are not properly made in writing if they are not, yeah, even not made in writings. Yeah, maybe the close relationship between business players sometimes put their commitment on in oral only. Yeah, so and then they just I mean do that or presume that with a good faith and gentleman's agreement between parties, that makes, yeah, sometimes that when it comes to source or come to a war situation, they may not remember what they say. Yeah, that's sometimes the point, and this comes to the problem of evidence. Yeah, so I mean, in others they put that the deals in writing, but they put that in unclear wordings. Yeah, I think because as the experts say that you must write what you want, not you write what you think, because there must be very small difference between what you think and what you want, because what you do in in contract is what you want, what is the real objective you have in that. So if there is the difference between what you think and what you want in the contract, that might create problems. I mean difference between what you think and what the other party thinks. Yeah. So what we want. So it must be put in a very clear wordings, in a very clear words. Yeah. And also with the language that we understand. So many Indonesian business players put the contract in English, but when we ask them about English, they have only, I mean, they in many experience, they have very low capability in understanding English words. So that makes sometimes a problem that they may not be very well understood what they have committed. Yeah, and then the other is capacity of the contracting parties. That becomes one other problem. So one of the contract party is bad faith party. Yeah, I think this happens everywhere. We have good parties, we have bad parties, but this can also be mitigated by trying to learn the other parties, their reputation as well as their formal capacity before we come to the contract. So one of the contracting parties faces financial problem. So this is other problem, and this is, I think, becomes more popular problem now. Because what? Because this pandemic makes the situation get worse. Yeah. So many business players now faces problem, especially the middle to low. Because what? Because we have what we call regional lockdown. We don't say that all, but in regional area, there has been a limitation of moving for peoples, and also for goods have been has been placed right now. So I heard that Hong Kong is much better situation, and also Byron will explain about that. People in Hong Kong does not really put mask now or wear mask now, but because I heard that your situation is much better. I think we will love to hear from Byron later about this. So the object of the agreement is unlawful or forbidden. So in Indonesia, this is one of the very fundamental principle of contract, that the objective of the contract must be lawful. Yeah. So we must have a good cause. So there is a problem of dispute coming from others. So others start doing default, and their inability to perform creates problem to others. So this creates a more potential problem to bring parties to the dispute. So what's the people must give a very strong point or notes to these all causes of disputes. Yeah, from the beginning of drafting the contract, business players or contract drafters must put a very strong intention how the dispute must be settled. Because we have two types of way of settling disputes. First, we call that by laws. The other one is by contract. So if I can move to my second presentation, please. So you will see that from Indonesian point of view. I think later we will go to the views of international point, but we start from our the views of Indonesian way to settle disputes. Yeah. So we have two ways of settling dispute. First is by laws, and the one is by based on an agreement. So by laws, we have Article 1266 and Article 27 say that by laws, when the business players come to the disputes and
Hello, Mr. Ricardo. Hello, could you hear my voice?
the disputes are settled out of the court process. Yeah, out of the court process. So that's what we call then what is the alternative out of the court? The alternative of the court is arbitration. Yeah. So there must be a very clear point in the contract where the party will go to settle their problem, through the court or through the arbitration process. So in our focus now, as we see, the trend is now people are business players prefer to settle their problem to arbitration process. And internationally, if we see that international people wants to settle that through the arbitration, yeah, with so many reasons actually. Yeah, I say that it is close. Dispute settlement mechanism, and the people can also propose the expert to be panel of arbitration, even though they must be they must be very independent. And I think so many plus point. That people think from the opportunity of settling the case through the arbitration process. So if we can see that the pictures of the whole of dispute settlement mechanism in Indonesia will be like my third paper, please. So this is the pictures. Yeah, this is the so this is the pictures of we see that we have court, yeah, as a bylaws dispute settlement mechanism. So in the court now we have a new court, what we call that special court, that we call that commercial court. Yeah. So this is especially for settling disputes for inability of the debtor to pay due and payable debt. So this is, we have two types of civil dispute settlement through the court. But out of the court we have alternative dispute settlement resolution. Yeah, alternative dispute settlement out of the from the court or out of the arbitration. So the out of the court is arbitration. In Indonesia, we have two types of arbitration. One is ad hoc, the other is institution. Now, institution we have two. Yeah, that's BANI. Yeah, one of the very popular. I think this is one of the strongest institutions in Indonesia for settling the case through arbitration. So we are now trying as well to what I call that, to promote this as maybe Byron also wants to fairly promote Hong Kong International Arbitration Center, which is one of the institutions that is very strong as well in ASEAN. So out of that we have arbitration, especially for financial problem. That's LL.M. This is the news. This is the latest arbitration center, which is established, supported by OJK. Yeah. So this is focusing on settling disputes like banks dispute, insurance, pensions, and others. So this is focusing to the financial instruments. So outside of arbitration, we have also alternative. Yeah. Even though we call that mediation process, adjudication. So adjudication is not the thing. It's not the thing that we apply in all, but especially for the consumers, settling consumers' problem in Indonesia. Yeah. So we have in-court mediation as well. That's mandatory. Before we don't have that, but now we have the mediation process. Okay, please continue. So if we see the pictures, so we see that we have local or national arbitration institution, yeah, out of the ad hoc, of course. We have BANI, we have Arbitration Syariah, we have LL.M, but out of our that we have neighboring arbitration institution. From Singapore, we call that SIAC, Malaysia before KLRC, but they now put with the new name of AIAC, and Hong Kong, we have Hong Kong International Arbitration Center. So this becomes increasingly important to be considered as the alternative for people, since we have more and more or increasing business players from Hong Kong, even from China Island as well, to come to Indonesia. So this will be, a new alternative that Byron can explain later. Please. So we have one interesting point of arbitration agreements. As I explained before, that the party must decide, because as I said, that there are two ways of business players settle their disputes. First is by laws, and the other one is by contract. So by contract, meaning that we can put in the contract arbitration clause or arbitration agreement confirming or stating that the dispute must be settled to the arbitration, or we can put that after. We forget to put that in the arbitration, but we agree that after the dispute take place, right? So how far? How strong this arbitration agreement? This agreement, arbitration agreement or arbitration clause, recognize what we call the severability principles, meaning that this arbitration is stand independently out of other clauses. So what happened is, for example, even when the main contract was argued to be null and void, it does not it does not influence the lawfulness or the validity of the agreement. So in many cases, sometimes the other parties say that the contract has been terminated or the contract has been is void. That's why the arbitration agreement in the contract itself must be void. But this is the argument that is not taken, because especially in Indonesian arbitration law under Article 10, it is recognized that the arbitration agreement stands independently out of the other agreement in the body of the contract. Please continue. Before, please. Yeah. So there are 3 points that the arbitration can offer to the dispute parties. Yeah. Still under Article 45 of Indonesian arbitration law, the disputing party are offered chance as to settle the case amicably. Yeah. So under Article 45, say that if the dispute party can agree to settle amicably, then the case will be closed and the arbitration will issue the judgment based on the settlement. Then the second is binding opinion. I think this is, this principle actually applies everywhere in arbitration, but let us hear from Byron later about Hong Kong arbitration, International Arbitration Center. So binding opinion, I think, must be studied from the both parties to ask the arbitration, for the arbitration to decide what actually the solution of the dispute happens between the business players. So the other one is if there is no chance to settle amicably, or there is no intention of parties to ask for a binding opinion, then it is the role of the arbitration to examine and also decide the disputes through the competency of the panel of arbitration, which is given by the parties through the contract. Yeah. So I think I'm going to describe a very fast about this my coming paper, since we have very limited time. Yeah. So this is part of the party that can involve in the arbitration process. We have arbiter, could be single and panel. Yeah, this must be agreed as well from the first by the parties. Yeah, we have claimant, we have respondents. We can involve fact witnesses, or expert witness or witnesses. Third party intervention can as well be recognized in this process. We have the registrar, and also we have the court. So the court here is not to involve, the court is other party, because we have a very clear principle, in our law, that when party agrees that the dispute is settled through the arbitration, the court is not competent anymore. So absolutely not competent to try the case. Not only the court, but the party as well are not competent absolutely to bring the case to the court. So we have this is in Article 3 and Article 11 of Indonesian Arbitration Center. So very clear that the agreement, the arbitration agreement makes the court absolutely does not have competence to try the case. They must reject the case, since the case must be resolved in the arbitration as the consequences of the arbitration law. Please continue. So this is the points, the points of the decision. I think we can see part of that, and we bring this to the discussion. Wait a moment, please. Okay. Continue, please. So in Indonesia, for the decision of the arbitration, even though according to Article 60, that the decision of arbitration is final and binding, but we have the system, yeah, based on when the parties prove there is a fundamental, what do you call that? Errors or fraud happens in the process of arbitration, the party can have a chance to annul the arbitration center. That's for the national arbitration center. Yeah, but it is regulated under Article 70. So I think I put that here the reason for that. Yeah. So maybe it was found that the documents are falsified or fake. Yeah, or the parties or the arbitrators does not give handle the case independently, or something like a point that comes to the very fundamental point that the decision was should not or was not supposed to be put like that because of the fraud. So we have this in Indonesia, yeah, for the decision of the arbitration, but practically, I think more in more cases, this way of or this what do you call that? The opportunity for the losing party to annul the decision of arbitration through Article 70 in many cases was rejected. I don't say that it is not allowed, but I mean the party must provide the strong evidence to prove in order to annul the decision of arbitration, since the decision of arbitration is clearly stated under Article 60 is final and enforceable. Continue, please. Yeah, I think I just put this in here for the discussion. Continue. Yeah, now we move to international aspects. Yeah, so I think as we know that we are the members of the New York Convention 1958. Historically, it was not easy for us to just come into the commitment of international the New York conventions. Yeah, so even though at the time very long time ago, even 1981 we have committed, yeah, to be the member of the New York conventions, but unfortunately we found various reasons of way of Indonesian court to involve and confirm that international arbitration award is not enforceable, is not valid in Indonesia. We have so many experience, but what is the point here? We develop from the process, yeah, from the idea of there must be a next regulation such as Supreme Court 1990, and now we come to the better situation by putting, or by what do you call that, by putting the commitment of international arbitration to Article 65 of Indonesian Arbitration Center. So what is the consequences of this? The consequences of this, that the commitment, the finality, then enforceability of international arbitration award is not only based on the commitment of us to participate or to ratify the New York Convention, but because it has been put, in our national law, in our arbitration law, as a law confirm that we recognize the finality and enforceability of the international arbitration. So that's it is. So we see that in Article 65 of Indonesian Indonesian Arbitration Center. Even though there is one point, what we call that Article 66 for us to be put as a requirement for the international arbitrations award to be enforced in Indonesia. But one point that, as a member of the New York Convention, we cannot annul international arbitration award. Indonesian court does not have a right to annul Indonesian international arbitration court, because according to Article 5 of international of the New York Convention, the one that has a right to try again the international award is only the country where the arbitration or international arbitration award was made. So this is the situation that regulated as well in our law, and also has been practiced in our recent decisions, court decision. Please continue. I think I have another one.
Sorry, Mr. Ricardo, you still have 2 more minutes, 3 more minutes.
Yes, thank you.
Please make it brief.
So Article 66, I think that's as I say, that's a requirement, for the international arbitration to be acknowledged and enforced in Indonesia, because the acknowledgement of enforcement of the international arbitration award was go to the capacity or to the capacity of Central Jakarta District Court. The chairman of Central Jakarta District Court. The chairman of Central Jakarta District Court is the institution or the court that has a right to acknowledge and or to recognize the enforcements of the international arbitration award by giving exequatur. Okay, continue. So this is the regulations, of the New York Conventions. Article 5 of A that clearly stated that the party that has a right to try again or to annul even the decision of international arbitration award is the country or the court where the international arbitration award was made. And we have, before I close my presentation, continue please. So we have that this is one of the famous cases about the Karahabodas, confirming the what I call that, the statement of our Supreme Court confirming that the decision of international arbitration award cannot be annulled by the court in Indonesia. It can only be tried or annulled if there is a reason for that by the court where the international arbitration award was made. So this is the picture of arbitration as a alternative dispute resolution, and we have now the trend that people or business people go to the commitment and also to the belief that international arbitration becomes a better and also more what I call it, more trusted way for the people to settle international business disputes in the world. So I think this is the thing. This is important point that lawyers must understand, arbiters must understand, institution must understand to promote a good, transparent, efficient, and trusted. A point of their each institutions as a place of business, international business players to go, and especially in the area of ASEAN, which is where Indonesia is one of the biggest player. I think this becomes an alternative to settle the feature. I want a feature, but the potential of international disputes. I think this is my presentation, and I'm ready to discussion, and I'm also happy to hear explanation from Byron, please. Thank you.
Okay, thank you very much, Mr. Ricardo. Okay, so we have listened that international award can be executed in Indonesia. Okay, so that means if we want to solve the disputes through the international arbitration, it will be better. So that's why now we have Byron Perez as the representative of HKIAC to explain to us, to share to us about the arbitration. Okay, let me read his curriculum vitae. His name is Byron Perez, and his nationality is Philippine, not Indonesia, as he told me before. Because many people think he is Indonesian. Okay, and then education and qualifications. LL.M, International Dispute Settlement, Graduate Institute of International and Development Studies and University of Geneva. GD, Ateneo de Manila University School of Law. PA, Ateneo de Manila University. Byron is a counsel or a supervisor in HKIAC Arbitration Team. Prior to joining HKIAC, Byron clerked at the Permanent Court of Arbitration (PCA) in The Hague, where he supported tribunals in high-profile investor-state and interstate arbitrations relating to oil and gas, mining, infrastructure, and law of the sea. He previously worked as a lawyer of the Republic of the Philippines and as an associate in a Philippine law firm specializing in litigation and arbitration. Okay, for your interest and for the information that you may ask the question after this, you may read the rundown schedule. Okay, Mr. Byron Perez,
yes.
Are you ready for your presentation?
Can you hear me well?
Yes, it is great. Okay.
So thank you, Ketut, for the kind introduction. I'm Byron Perez. I am counsel at the HKIAC, or the Hong Kong International Arbitration Center, and I'm very grateful to be with you this morning, at least virtually, in order for us to discuss arbitration. If Ketut, maybe your assistant can put my slides.
Okay, host, please help Byron Perez to share screen. Okay, here you are, Byron.
Okay. So as Mr. Ricardo has said, arbitration is an alternative mode of dispute resolution. So if in the past, the default mode of dispute resolution for contractual disputes primarily, which is the purpose of our discussion, is to go to court, parties may also resort to arbitration. So what is, as Mr. Ricardo said, arbitration is a creation of the agreement of the parties. So there should be, in the parties' agreement, a provision stating that the parties will resort to arbitration in case of a breach or a dispute over the contract. And Mr. Ricardo has also discussed the parties to an arbitration, such as the claimant, the respondent, the arbitral tribunal, which could be a sole arbitrator or a three-member panel of arbitrators. And so you might be wondering, where does an arbitration institution such as the HKIAC come in. So as Mr. Ricardo has said, when you have an arbitration clause in your contract, it could be without naming any arbitration institution, then that would be classified as an ad hoc arbitration. So an ad hoc arbitration can move forward only if the parties to the arbitration voluntarily participate in the arbitration. However, if one of them does not respond to the other party, then it may be difficult to proceed with the arbitration. Now, the counterpart of what you call an ad hoc arbitration is what you call an administered arbitration. And this is where the HKIAC comes in. Next slide, please. So the HKIAC is an arbitration institution. Our role, as Mr. Ricardo has said, comes to life only if in the contract the parties agreed to submit disputes to arbitration by HKIAC. So without naming HKIAC in the contract, HKIAC will have no role. Of course, when a dispute arises, the parties can subsequently agree to have an HKIAC arbitration. So just a brief introduction on HKIAC. So we are a non-profit, non-governmental organization organized in and founded in 1985 by persons from the business sectors and the legal sector in Hong Kong. And currently we are the number 3 arbitration institution. This is according to the recent rankings released in May by the Queen Mary University of London and the law firm White and Case. So we are now number 3 next to SIAC in Singapore and ICC, which has offices in Paris. And in addition to arbitration, we also provide mediation services, adjudication, and domain name disputes. I believe Mr. Ricardo has discussed mediation briefly. And just for your background, domain name disputes would typically be, let's say you have Smart Wikan's website, correct? And then another person in, let's say, Philippines registers smartwikan.org. So Smart Wikan Indonesia, which is the rightful owner of the domain name smartwikan.com, can file a case to stop that person in the Philippines from using smartwikan.org. So that's a basic example of a domain name dispute. Next slide, please. We have offices in Hong Kong, which is the main office. We also have a representative office in Shanghai and in Seoul. Next slide, please. And this is a slide showing our facilities in the Hong Kong office. So well, if you were not under the coronavirus pandemic now, then our location would be easily reached from the Hong Kong airport. You take a fast train and then you reach our office in central Hong Kong. And we have also dedicated hearing support. We have recently hired the virtual hearing managers to cope with the virtual hearing needs necessitated by the coronavirus pandemic. And we have a lot of hearing space at which we would be glad to welcome you when the pandemic is over. Next slide, please. And as I said, we offer not only arbitration services, but also mediation, adjudication, and domain name dispute resolution services. And we also organize events and participate in training such as Smart Wikan's current webinar where we are today. This is part of our commitment to to the development of the legal culture, not only in Hong Kong, but in other countries as well. Next slide, please. So as I said, the HKIAC is a non-governmental organization. I get asked many times whether HKIAC is a part of the Hong Kong government. No, we are not part of the Hong Kong government, even though we have HK in our name. So the structure, so HKIAC is headed by what you call the Counsel. So we have David Rivkin, who is an American partner at the office of the Bevois Plimpton in New York. And we have Rimsky Yuan, who is the former Secretary for Justice of Hong Kong. And then what might be of more interest to you is how cases are run. And so if you could focus to the Proceedings Committee and the Appointments Committee and the HKIAC Secretariat. So the HKIAC Secretariat is what you could call the engine of HKIAC. Without HKIAC, without the Secretariat, there would be no persons to administer disputes, to accept a new arbitration case, to inform the parties that they have to appoint arbitrators, and other incidents in the life of an arbitration. Next slide, please. So this is just an elaboration of the previous slide, showing the faces of the persons comprising the Secretariat. Next slide, please. And I remember Mr. Ricardo saying that the COVID-19 pandemic actually gave rise to a lot of cases. And this is true. We observed this, especially from our 2020 statistics. There was an increase in the overall number of cases we administered. So from 308 in 2019, we increased by around 10 to 318 in 2020. Next slide, please. And of course, the types of disputes that we handle are mostly international trade. So you could have an Indonesian buyer buying N95 masks from Hong Kong, and let's say the Hong Kong supplier did not deliver, and so that's a typical trade or sale of goods case. And given Hong Kong's location, as you know, it is also a maritime hub, so we get a lot of maritime disputes. And then also owing to Hong Kong's financial standing, we also get a lot of corporate and financial disputes, including banking disputes. And you can see on the slide the other types of disputes that are prevalent in our cases. Next slide, please. And in 2020, we have on the slide our top 10 users. So, of course, the first is Hong Kong, mainland China, followed by mainland Chinese parties, BVI, the USA, Cayman Islands, and Singapore. You may be wondering why we have BVI and Cayman Islands parties in our cases. These BVI and Cayman Islands parties are actually holding companies of mainland Chinese corporations. So these mainland Chinese corporations who are based on the mainland, they have a holding company for tax, for tax purposes, for compliance purposes. They established a holding company in the British Virgin Islands or the Cayman Islands. And they do business with these corporations, and then these corporations then get sued by their counterparties in their respective contracts. But of course, I would like to emphasize that these are only our top 10 users. Our users span worldwide. We have European parties, we have ASEAN parties, Philippines, Indonesia, as I will show later on. Next slide, please. And we already discussed this. We had a record year in 2020. In addition to our 318 arbitrations, we also handled 149 domain name disputes and 16 mediations. Next slide, please. And for more statistics, the total amount in dispute that we handled last year was 8.8 billion US dollars. And most of our arbitrations are conducted in English. And the seat, Hong Kong, just to explain briefly on the seat. So the concept of the seat of arbitration is, as you know, arbitration is a creation of the parties, right? But it has, in one way or another, has to be tied to a national law system. So let's say you have a seat of Jakarta. So if you have a seat of Jakarta, the arbitration law of Indonesia will apply to any arbitration commenced with having a seat of Jakarta. Next slide, please. And an important thing to consider when choosing arbitration institution or seat of arbitration is especially, and I would like to emphasize this, especially if you have mainland Chinese counterparty, is the recent Hong Kong People's Republic of China arrangement on interim measures. So previously, the PRC courts would not issue interim measures, let's say an asset preservation order, in aid of an arbitration which is not seated in mainland China. So let's say in the past, let's say you would have a Chinese claimant, American claimant versus a Chinese respondent, but the seat is New York. If the American claimant wants to freeze assets in, let's say, Beijing, it cannot take advantage of any interim measures from the Beijing courts. So, however, in 2019, the mainland Chinese Supreme People's Court and the Hong Kong government entered into an arrangement whereby the mainland Chinese courts can now issue asset preservation order or evidence preservation order in aid of arbitrations seated in Hong Kong only. And in furtherance of this agreement, the parties must be parties to HK seated arbitration. So as I said, the seat must be in Hong Kong. And next slide, please. So we have here on the slide our practice when, let's say, you have an Indonesian claimant against a mainland Chinese claimant, and the Indonesian claimant wants to preserve assets of the Chinese respondent. Because the importance of interim measures is, while an arbitration is ongoing, the other party may hide assets, So in our example, the mainland Chinese party may, transfer its assets to, let's say, its holding company in the BVI or in Cayman Islands, such that at the end of the case, when an award in favor of, in our example, the Indonesian claimant is issued, the Indonesian claimant will not be able to satisfy the award because all assets of the mainland Chinese respondent is nowhere to be found. So by taking advantage of this interim measures arrangement, the Indonesian party can secure enough assets to satisfy an award that may be issued in its favor after the conclusion of the arbitration. Next slide, please. And we have here some statistics on the interim measures that HKIAC has processed to date since October 2019. We have processed 47 applications, again for preservation of assets such as freezing orders, evidence, and conduct. And the applications amount to around 2.2 billion US dollars. And the mainland Chinese courts have actually been very helpful in that they issued orders amounting to $1.7 billion. And you will also see that most of the claimants seeking interim measures from mainland Chinese courts are foreign claimants. You will see they're about 76% in our 47 applications. Next slide, please. And in addition to the interim measures arrangement, we also have in place an arrangement between Hong Kong and the mainland China on the enforcement of awards. So this is similar to the New York Convention as discussed by Mr. Ricardo. And to date, we are pleased to report that only 3 HKIAC awards have not been enforced in the mainland in the past 20 years. Next slide, please. And as you may know, given Hong Kong's location and proximity and to mainland China, as well as cultural familiarity between Hong Kong Chinese and the mainland Chinese, we have developed an expertise in China-related disputes. And as I said, this is supplemented by or reinforced by the interim measures arrangement, the enforcement of awards arrangement, and as well as the fact that most parties in our caseload are mainland Chinese parties. Next slide, please. And in addition to administering arbitrations, and I would again like to emphasize, Indonesian parties can choose HKIAC not only when they have a mainland Chinese counterparty. I mean, HKIAC can administer all types of disputes involving different types of nationalities. The parties are not limited to Hong Kong or mainland Chinese or holding companies of mainland Chinese. We have also expertise in handling investment treaty disputes. In 2019, we handled an investment dispute against the Republic of South Korea. This is public, so I can mention it. And also, several members of the HKIAC Secretariat have experience administering investment treaty disputes under the UNCITRAL arbitration rules. And we also offer a tribunal secretary service. So for those who are not familiar, tribunal secretary is an assistant to the arbitrators. So the tribunal secretary could assist in performing research or performing tasks, administrative tasks, provided that the tribunal secretary does not arrogate, how do you call that? Does not the decision-making function does not devolve to the tribunal secretary. So the decision-making function is always reserved to the arbitrator or arbitrators. Next slide, please. And you may be all wondering. Sorry.
Yeah, sorry, Mr. Byron, you still have 5 more minutes.
Okay, yeah, I'm almost done, I think. And I would just like to emphasize that Hong Kong has a very pro-arbitration legal framework. This is we have the Hong Kong Arbitration Ordinance, which is patterned after the Uncitral Model Law. And I believe we discussed the other items on this slide. Next slide, please. And also, the Hong Kong judiciary has a very international character. For arbitration cases, we have a specialist arbitration judge, and she is not Hong Kong Chinese or mainland Chinese. She is actually from Brunei. So if ever you have a case requiring the annulment of or enforcement of an award, it goes to her. And our Court of Final Appeal also includes former judges from the UK, Australia, and Canada. Next slide, please. And of course, Hong Kong has always ranked high in the judicial independence rankings. In 2019, we were first in Asia and 8th worldwide. Next slide, please. And just to show how we adopted to the COVID-19 pandemic, preventing parties from conducting their hearings physically, HKIAC has put in place equipment as well as personnel to be able to address virtual hearing needs of the parties in our cases. And also, our virtual hearing services are available not only to parties in our arbitrations, but also to parties in non-HKIAC arbitrations. Next slide, please. And of course, as you may know, as parties in the past have always been used to physical hearings, there are also some issues that need to be addressed in respect of virtual hearings, such as security and confidentiality. And more importantly is the due process concern, because if in the past a party feels that he or she is able to present the case or defense fully, in virtual hearings, there is no physical presence. You don't sit across the arbitrator and you don't sit across the witness you are cross-examining. So there is the need to address due process concerns, as well as, because due process concern or issues may lead to the annulment of an award under the New York Convention. Next slide, please. And we have also guidelines for our virtual hearing services. Of course, the parties and the tribunal are always free to agree on their own. Next slide, please. And just some statistics on our experience with virtual hearings. In 2020, we handled 68% of our hearings were virtual out of 117 hearings. Next slide, please. So I just have here on the slide our 2018 HKIAC Administered Arbitration Rules, where we have introduced time and cost-saving measures. And I believe for the purposes of parties, especially Indonesian parties, time and costs are paramount. So next slide, please. So in terms of costs, the parties are actually free to agree on how they pay the arbitrators. So it could be on an hourly rate or based on an ad valorem scale depending on the amount in dispute. And we have also introduced a cap on the maximum chargeable hourly rate of arbitrators in our administered arbitration. So it is capped at 6,500 Hong Kong, which is around 800 US. Next slide, please. So just as an example of the importance of paying by hourly rate or by ad valorem, if you have a large amount in dispute, which let's say 100 million, however, it is a simple case, if you choose to pay the arbitrator ad valorem based on 100 million, you will end up paying 264,000 Hong Kong dollars. However, if you pay the arbitrator per hour and that arbitrator charges 500 US dollars per hour, you will only end up paying 150,000 US dollars for the same number of hours. However, choosing to pay by ad valorem may also be beneficial in cases where the amount in dispute is low. In this slide, you see that where the amount in dispute is 5 million US, you only pay around 100,000 US. Next slide, please. Next slide. I believe we can skip this. Next slide, please. Next slide. Next slide. Next slide. Oh, so we just have here on the slide, and I'm sure you will receive all the materials from this presentation. A model clause which addresses all the items that should be included in an arbitration clause. Because one of the problems is you could have an arbitration clause that is incomplete. Let's say the seat is not identified or the number of arbitrators is not identified. Next slide, please. And HKIAC also maintains a panel and list of arbitrators whereby the parties can choose their arbitrators. Of course, I must emphasize that parties are not constrained to choose their arbitrators from this panel or list. However, for specific needs for the dispute, let's say language skills, the list, the panel list that we maintain on our website is very helpful. Next slide, please. And we actually have identified 2 Indonesians on our panel and list, Professor Dr. Winarta and Tony Budijaja. Maybe Mr. Ricardo would also like to apply. You can message me separately.
Thank you. I will.
Yes.
Yeah, Mr. Byron.
Yes. And next slide, please. And finally, the slide on our statistics involving Indonesian parties. So since 2010, we have handled 20 cases involving Indonesians, and the types of disputes range from commercial, maritime, and corporate. And we have noticed that the seat chosen was Hong Kong, and the nationalities of the counterparties are, of course, Hong Kong, mainland Chinese, and again, that BVI company, which is likely to be a holding company of a mainland Chinese company. And interestingly, we have had one case where both the claimant and the respondent were Indonesian. So they chose Hong Kong for their dispute, for arbitration. And the amount in dispute for these 20 cases is around 92 million US dollars. And next slide. I think that's the end of my presentation, and I hope you found it interesting. Thank you.
Okay, thank you very much, Byron.